to what is going to happen next. Now, as you know, there have been various attempts by the usual suspects, pointy heads, a lot of them, to mount challenges to putting the President's name on the ballot. Most of these challenges were depressingly ill-conceived, poorly researched. The evidential chain was not clear. They didn't put in proper affidavits. One of them even applied to the Supreme Court rather than the Court of First Instance. Mistakes all over the shop. And in just about all of those cases, if I had been the judge, I would have thrown them out, which is exactly what the judges did. What has happened as a result of this foolish behaviour by people who got overexcited and didn't get proper legal advice and do it carefully is that they have probably more or less shut down any possibility of pursuing this matter by way of the civil route, where you go and you challenge the right of the Democratic National Committee to nominate the President, or you challenge the right of the Secretary of State for your state to put him on the ballot. That route has pretty much been closed off because the judges have been so fed up with these people that they simply refused to give them standing to be heard at all, and in making that finding, they have established a precedent. There is one exception, and that is the poor guy who made the mistake of going to the Alabama Supreme Court instead of the Alabama State District Court, where he would have been given a hearing. But what was interesting about the Alabama court, at first, they simply issued a piece of paper saying, we reject this out of hand, without saying why. But one of the judges, a wise old bird, name of Tom Parker, a very senior judge, of the Supreme Court of Alabama, we're not talking about some pointy head here, it's a serious judge, he issued what is called, rather perplexingly, an unpublished opinion, because the court published it alongside the court's findings. And what this published opinion said is that very clearly there are grounds for profound concern as a result of what was put in the documents submitted by Mr. Hugh McInnish, the plaintiff in this case, to the court. He said, I'm sorry, we can't deal with it because you have to go to the lower court first. And he said, you also have to have a proper affidavit and not just make wild allegations and not put your name to them. You have to do it right. And the guy essentially represented himself, which is why he got so much wrong. But the court having made that remark obiter, which means just in passing, that there's clearly something that smells here, it is very likely that if either Mr. McInnish or any citizen of Alabama were to go to the State District Court and include among the paperwork the unpublished opinion of Judge Tom Parker, then the State District Court would feel more or less obliged to give that plaintiff standing. In other words, the right to be heard in front of the court at all. So you heard it here first. I think that one of the things that is going to happen next is that somebody in Alabama is going to wake up, come off the Kool-Aid, realise that the judge has handed them this case on a plate, and go along and file an action, whether against the Democratic National Committee or, more likely, if it's the State District Court, against the Secretary of State for Alabama, or whoever it is, I'm not sure who it is in that state, who is the electoral registration officer for the presidential election as part of the general election on the 5th of November 2012. So that's thing number one that I think is very likely to happen, regardless of what you or I or anyone do or think about this. But there's something else that's going to happen, because not only did I consult forensic experts so that I could show you what was wrong with the document on its face and what was wrong with the document electronically when you go behind what you see there, but also I consulted one of the most eminent constitutional lawyers in the country. And that lawyer spent one of the most fascinating hours, from my point of view, on the phone that I have ever had. And he said he was astonished that this matter had not yet been brought to a resolution for two reasons. One, he agreed with me that a president obviously worried by this, and the department in Hawaii obviously fed up with all the inquiries, would have done the obvious by now and opened the books to forensic investigators for both sides in an open and perfectly natural way. But the other thing he said was that to overcome what he saw as the formidable problem of getting standing in a civil action, the one person who unquestionably always does have standing to ask just about any question, look at just about any document that might be relevant to his case, is the defendant in a criminal case, where the prosecution has alleged that he's committed a crime that was signed into law by a statute signed by President Obama himself. Any new crime created by President Obama, for instance, if you look at the National Defense Authorization Act, you find a number of crimes in there. We may not think those crimes ought to be crimes, but they're in the Act. It was passed by Congress and signed by the President. And under your Constitution, it has to be either signed by the President, or if he doesn't get round to it for 10 days, then it can become law. But he signed it, and therefore that act is only an act because he signed it. And so if a criminal defendant charged under that act, and his attorneys wake up and realise this point, which I got, not because I'm clever, because I was given it by this very eminent constitutional lawyer, then all he has to do is to say, right, I'm playing what's called the Brady card. Now, Brady and Maryland, 49 years ago, was a case which established the principle that if the defense requests from the prosecution any evidence, document, material, or other matter which is in the prosecution's possession or control, and which might be of assistance to the defense, the prosecution is obliged to hand it over without arguing and no questions asked. So it is open to the attorneys for anyone charged of a crime signed into law by President Obama to play the Brady card, as it's known, and say, I don't think that the act of Congress, which I'm being accused under, is a real act of Congress. And if it isn't, then the criminal offences that it creates don't exist. And therefore, I'm home free. Even if I did something wrong, I'm out of here. And so what is the President going to do? He signed all these things into law, and according to the constitutional lawyer, it is only a matter of time before a firm of attorneys somewhere wakes up and realises that they can say to the judge, we want forensic investigators on our behalf to go and look at the original records in Hawaii to satisfy ourselves in view of the legitimate doubt on the matter created by the fact that a seasoned law enforcement officer, after a 6-month investigation, has found legitimate doubt about whether this document is genuine. We want to check that it is genuine before we will accept that that act is validly passed or made. And the defense has the absolute right to do that. So that is going to happen at some time in the next few months. I can't say when or who, not my business to. But that it is likely to happen is something which the constitutional attorney whom I consulted thinks very highly probable. So what advice then would one give to those in the administration who are at the moment rather carefully looking the other way on this matter? It is simply this. It's far better, if you are in government, to try to keep control of those events that you can control, because otherwise events that you can't control may bring you down. And so once again, this points to the President taking the initiative before he's forced into it by either a civil case in Alabama or a criminal case anywhere. And he simply opens up that record and allows people to see it. Now, I've given you quite a lot of detail about this because I was specifically asked by the organisers that I should concentrate chiefly on this issue. And what I hope you will have gathered from what I've said is, first of all, that Britain does have a legitimate interest in seeing that the United States does not fail, particularly at this time of economic crisis. Very important that your president should be fully in command of events as far as it is possible for him to be. So I am not here to say to you, your president isn't your president, or ought not to be your president, or I don't like his politics. I'm not saying any of those things because it is not my business as a guest in your country to say them. What I am saying, in friendship across the Atlantic to your great nation, is that you really cannot simply ignore your own constitution. There's a notice here which puts it in a nutshell. Obey the Constitution. And I was talking to a very senior Republican lawyer about this, to say, why are the Republicans, among most of the establishment, not touching this? He said there are various reasons. One is the pointy heads. Everybody who has stood up on this issue has made wild accusations, pushed it beyond where it would go, clearly playing politics. We don't want to get into that. The next reason, which I heard from Congressman Jim Sensenbrenner, who's an old friend of mine and probably got the best head on him of anybody in either house of Congress, he said, hey, if we knock out Obama, we'll get Joe Biden. I thought that was quite an entertaining reason, but this lawyer friend, he said the other thing is, he said, you know, it really doesn't matter. And I said to him, just a moment. And in fact, there's a fellow called Geraldo Rivera, you know, he interviewed me on this the other day. And he started off in that marvellous way he has. First of all, he said, you're on crack. Then he said, you are a racist. Then he said, you're not a real lord. Then he said, you're a birther. Then he said, you're a climate denier. I mean, 5 insults in about 30 seconds. I was rather taken aback, having been invited onto his show. But anyway, he said, of course, none of this mattered. And they had some awful Marxist from a pressure group on the other side saying, of course, that Obama was a saint and anybody who raised this question was a pointy head and ought to go and get a life and all that sort of stuff. So I simply said this, I said, look, I'll tell you why I think it matters. Because unlike us, you have a written constitution. And your constitution says it does matter. And when I said to the constitutional lawyer I consulted, does this actually really matter? Do we need to worry about any of this at all? Are we not all wasting our time? Can't we just let him be president, even if he did come from Kenya or Indonesia or Mars or somewhere? I said, can't we just let him be? And the lawyer said, so what you're saying is we should ignore our constitution. I said, well, maybe that particular provision, which had a historical reason, we heard a bit about that earlier, is now defunct. It no longer really applies. I said, you know, there is an argument for that. He said, rather sniffily, he said, well, your constitution may work like that, he said. But our constitution is very straightforward. You amend it, or you abide by it. His word, not mine. So what I hope you have gathered from my remarks on this subject today is that I am not seeking to interfere in your politics. What I say because I love America. I do not want to see your country damaged. I do not want to see it fail. I do not want to see it brought low by the international sniggering behind the hands of diplomats and leaders of other countries who are watching this situation, have realized that there is something amiss and cannot understand why, at least at the very basic level of competence, this matter has not been definitively and swiftly addressed.